I thought we would do a bit of an update on some cases. That's the idea of this. I'm going to whistle through a few, and then I'm going to hand over to Rebecca to look at in more detail at a couple. And I was just picking out, there are always loads of cases around trademarks, but what are the key things? You will likely have heard of these. You may well have read them all, but in terms of bringing them all together, I thought there were 3 or 4 that were particularly notable. The first one is this Oatly case on Slogans. This was Oatly applying to register its like milk but made for humans. The reason I raised this case, it's unremarkable in a number of ways. It's simply an application to register. It's not a big dispute. But this mark was refused on the basis of it being a purely laudatory and marketing statement. And the refusal was overturned by the General Court. And the finding was that there was something there. In actual fact, the decision talked about the fact that the mark would start a cognitive process for the consumer. There are some interesting things there for us. We're always trying to register marks that you guys come up with or your marketing teams come up with, which perhaps are not as distinctive as they might be. This is a very useful decision. That test sparks a cognitive process is a rather more useful position than most of the recent case law on these sorts of things. And so this is quite a useful one for us. So I'm pretty pleased with where that's got to. I don't think it'll it obviously won't get appealed again. And so it's one that we're going to be citing quite a bit. Monopoly, you'll have heard of. We've talked about it before. The next round of the appeal has happened on this case. This was Hasbro refiling or doing the process of evergreening, refiling the Monopoly trademark. And having it invalidated or someone applying to invalidate on the basis of bad faith during a dispute. Their mark was found to be in bad faith, and the appeal has upheld that. So this is a specific set of facts. It's an identical refiling, so same mark for the same goods and services, and specifically where the tribunal, the court, has found that the only reason for the filing, the reason for the filing was to circumvent the rules of the EU trademark system, so to circumvent the non-use requirements. And unfortunately, Hasbro effectively admitted that during the case, which is one of the reasons we got there. Any difference in specification, difference in marks would not be caught by this case, but it's one that everyone is watching because of the general practice in the EU for doing this. So the appeal has upheld the underlying decision. It is being appealed again to the CJEU, so we will keep an eye out on it and we will keep you updated. 2 more very quickly. Skykick, everyone is sick to death of. Again, it's another one which is very important, not because of actually the underlying matter, which most people have forgotten, which was Sky suing effectively a software company called Skykick for use of that mark. The issue that has been addressed very heavily in all the cases is the breadth of Sky's trademarks and whether there was any bad faith angle on the breadth of those specifications. The original European court decision was handed back down to the UK, and that was implemented in the UK. The appeal has been heard, which actually overturned some of the findings of the UK court and effectively found that breadth of spec would not in and of itself constitute bad faith. And actually the big issue was around a broad term like computer software. Could the existence of such a broad term in a specification be justified by the possibility that one might want to use on a specific app? And the Court of Appeal in the UK found that actually any kind of commercial strategy to potentially use a mark within a broad term was sufficient to defeat any kind of bad faith claim. So again, that's a turn again in the Skykick story, and tends to again keep the possibility of broad coverage in relation to EU trademarks open. I don't think we've heard the end of it. It's been going on for an awful long time, but of course, again, it's a very important issue in the context of European trademark filing strategy. So that's why I put it in there. Last one on my little short list was a Miley Cyrus case. I put this in partly because of the interest in the fact that actually a European tribunal found Miley Cyrus to be famous without there being any evidence in front of them, which is ironic. We often talk about the fact that European tribunals are mainly happy to find European footballers to be famous, but not American pop stars. But here, there was some agreement between the parties that Miley Cyrus was famous. Here, her application for Miley Cyrus was objected to by an audio company called Cyrus, mark covering identical goods. And the appeal overturned an underlying decision which found there to be a likelihood of confusion. And the key point here was that actually the fame of Miley Cyrus effectively was something that could be taken into account in relation to similarity and likelihood of confusion. Someone seeing Miley Cyrus would understand the conceptual message that's being carried as her name as a famous person, and that it effectively defeated the possibility of confusion in relation to these marks. So quite an interesting one. Again, likelihood is we'll see some more cases around that, particularly around combinations of forename and surname. There's quite a lot of interesting comments around that. But the key point was this reputation issue impacting on consumer perception of the mark and impacting on the likelihood of confusion. So just there are 4 quite important cases over the last year or so in terms of the issues that are dealt with from a trademark point of view. And I'm going to hand over to Rebecca to talk about, a couple of perhaps more interesting ones. Rebecca, over to you.
Hi. Hopefully you've got the sound coming through there. If Rich is coming off the back of a Nature Valley, I'm coming off the back of a Tonix tea cake, which takes me straight back to birthday parties in the 90s and probably also gives away my age. So on that note, we're going to talk about 2 cases in a little bit more detail. These cases, so the first one is interesting from the perspective of similarity, assessment of similarity of trademarks. And the second one is particularly interesting because it deals with supermarket lookalike cases and how best to address those. So taking the first one, this is Chanel and Huawei. So the story here starts in September 2017, when Huawei makes an application for an EU mark in respect of the mark you can see there in red. So the application was actually made in black and white. That was a Class 9 application for various different types of computer software. Very shortly after that mark goes onto the register, in December 2017, Chanel opposes the mark on the basis of 2 of its existing marks. So you can see those 2 marks on the slide, the interlocking C device there and the interlocking Cs within the circle. So interestingly, these 2 marks were registered for slightly different classes. So the interlocking Cs was a Class 9 registration. So that explains Chanel's approach. Chanel brought a confusion claim based on the interlocking Cs in Class 9, as a confusion claim requires similar goods and services. But it then also brought an unfair advantage claim based on the interlocking Cs within the circle, because that type of claim doesn't require similarity of goods and services, and their mark there on the right was actually only registered in other classes that weren't Class 9. So this application went all the way. It was considered by the EU IPO Opposition Division, who rejected the opposition. Chanel then appealed to the Board of Appeal, who decided that they would dismiss this appeal based on the fact that the marks were not similar and there was no likelihood of confusion. And we get all the way up to the General Court. And the General Court, most of their decision here actually was focused on the unfair advantage section of the case. So they, at the outset, they helpfully just set out that an unfair advantage claim had 3 limbs. So you'd need identical or similar marks, an earlier mark with a reputation, and a risk of unfair advantage. So as a spoiler, the General Court didn't get beyond the first stage of this assessment. So that's the similarity stage. But it did make some interesting observations in the context of assessing the similarity between the Chanel mark and the Huawei mark. So in particular, the first thing it set off to confirm was that marks need to be compared in the form as protected or as applied for in this case. So that means that Chanel couldn't argue that if you rotate the Huawei mark through 90 degrees, it becomes visually similar to a very high degree. Instead, the Huawei mark has to be assessed as it's applied for, so vertically, making the shape of an H there, as you can see. The court then went on to do a standard assessment of similarity. So that was considering visual similarity, phonetic similarity, and also conceptual similarity. So when they looked at the visual similarity, they decided that there were certain shared characteristics. So particularly the black circles, the interlaced curves, the ellipse created between the curves there, and the fact that obviously it was all surrounded by a circular device. However, on a global assessment, they decided that actually the marks were visually different. And it's quite interesting, the detail of what they took into account here when they decided that on a whole they were different. They took into account, for example, the thickness of the lines, the curvature of the lines there. Obviously, the Chanel mark being a lot more curved than the Huawei mark with the straighter edges. They also went as far as to even consider in the Huawei mark, if you look closely, and you might not be able to see on these slides, but where the circles overlap in the Huawei mark, there is an interrupted line. They also took into account the length of the length of the sort of the actual curves. So in the Huawei sign, you can see there the point between the start and the end of the curve is longer than in the Chanel sign, where it's slightly more blunt. So the court did go into a fair degree of detail in deciding that visually these marks were different. Obviously, a phonetic similarity, the court wasn't able to assess on that basis, as the marks weren't able to be pronounced. Conceptual similarity was interesting because the court noted that although both were composed of a circle containing sort of an image referring to stylized letters, it said the mere fact of a circle can't make them conceptually similar. I think fine. But then it also went on to find that they were actually conceptually different based on the fact that the initials sort of being sought to be represented within that circle were different. So for Chanel, you have obviously interlocking double C, and for Huawei, you've got that as the basis for saying that they were conceptually different, essentially that they were seeking to represent a different letter. I think that's interesting because to me, they're a similar concept on a basic level. It seems slightly artificial to differentiate based on the fact that we're sort of, the fact that this interlocking device seeks to represent a different letter. Takeaways from this case, I would say if you're opposing a mark, don't think you can run a novel argument based on what the application looks like sideways. Also, might be worth taking into account that EU courts will look like they're going to be considering conceptual similarity at least to a fairly high bar. So I'm just aware of time. So moving on to the second case that we wanted to have a look at in a little bit more detail. And so this is a supermarket lookalike case, which is particularly interesting for us. And Julius will give a little bit of info a little bit later on how we are looking to approach supermarket lookalike cases in general. But in this case, very quick background. Hendrix have a shape mark covering the shape of their gin bottle and their label, as you can see there. That's a class 33 registration for alcoholic beverages. Lidl has been selling a gin called Hampstead Gin in its Lidl stores for at least 10 years. But this was majorly rebranded in 2020. And the rebrand came very close to the sort of distinctive style of the Hendrix gin bottle. Obviously, Hendrix not too happy about this, bring a claim. They bring a claim based on wrongs in Scotland. So it's brought in the Court of Session in Scotland. And the decision we have at this point is simply on an application for an interim injunction pending final decision. So nothing final decided here, and we are waiting the final decision in this case. But it's a very interesting indication of perhaps the way that these are going to go in future. So Hendrix brought 3 claims here before the Court of Session in Scotland. a confusion claim, a passing off claim, and an unfair advantage claim. And perhaps unsurprisingly, if any of you have been following these type of cases, they failed on the confusion and passing off aspects of the claim. So just looking briefly at these, for confusion, the judge assessed the marks side by side, and it essentially decided that the Hendrix Gin mark as registered and the later sign used by Hampstead Gin were actually visually and conceptually similar. So he considered, you can see there the style of the bottle, the color of the glass, the way the label is set out with scrolls, that he even went as far as to look at the juniper leaves on that label. However, he decided that in reality, consumers were not going to be confused between the earlier Hendrix mark and the later Hampstead Gin sign, sort of its get-up, its bottle. And this was based on the fact that the Hampstead Gin was sold only in Lidl, and particularly on its price point. The judge also noted that the difference in name would sort of help to make sure that confusion wasn't an issue. And this was similar then for passing off. The judge decided that there was very unlikely to be a prospect that the test for an actionable misrepresentation, as required for a passing off claim, would be satisfied here. So more interestingly, on unfair advantage, which is the way that we would usually run these claims, and really helpful and interesting to get sort of a affirmation from the Court of Session in Scotland here. So the judge was in no doubt that the Hendrix trademark, so the earlier trademark, had a reputation in the UK, which is the first stage of establishing an unfair advantage claim. And then he considered similarity on the basis that I've just previously described, and he decided that there was enough to establish conceptual and visual similarity between the earlier mark and the later sign. And then he went on to consider link. So unfair advantage claims require not only similarity between the marks, but that similarity to cause a link in the mind of consumers. He actually considered some quite interesting evidence based on consumer comments on a YouTube video, which I enjoyed reading. I mean, someone went directly in and said, looks like a complete ripoff of Hendrix. And someone else slightly more subtle reminds me of another gin, but I just can't put my finger on it. So those were the comments on social media around the Hampstead Gin. And the judge picked up on these and essentially said that it's evident from these kind of comments from consumers that when customers are looking at the Hampstead Gin, the earlier Hendrix mark is being called to mind. And on that basis, it's what the judge described as a transfer of image case. So there's been a transfer of the earlier reputable image of Hendrix Gin onto the later product because of the extent to which it has since sought to replicate key features of that mark. And so the last thing the judge considered on the unfair advantage claim was a change in economic behaviour. And it was helpful to have him reiterate this requirement here. And it's not a particularly easy requirement to establish, so that customers are changing their economic behaviour based on the get-up of the Hampstead Gin. So actually the judge here decided that Hendrix actually does have a very good chance of establishing this change in economic behaviour. And he interestingly noted that conduct is most likely to be unfair when it seeks to benefit from the reputation and goodwill of the earlier trademark, so that's the Hendrix trademark, in order to increase the attractiveness of a product, so the Hampstead Gin, to consumers. And so I think it's really helpful here to have just that affirmation that there's a reasonable prospect of success in showing that Lidl was basically seeking to enhance the attraction of its Hampstead Gin by adopting, I mean, I'm going to say a aspect, but various aspects of the earlier Hendrix Gin mark, and essentially the prestigious branded goods that represents. And the judge considered that there's a reasonable prospect that would be enough to establish a change in the economic behaviour of consumers. So very briefly, takeaways here: passing off and confusion, rightly rejected by the judge here. Customers are not going to be confused between these two marks when they're shopping in Lidl and the price point is £15.99. However, there is damage, and the damage well, there is potential for damage to be found, and that damage would be unfair advantage from mimicking the reputation of a reputable brand. And that would, the aim there is to increase the attraction of the Hampstead product to Lidl consumers. So it's great to see an unfair advantage claim being run here, and the Scottish court acknowledging that it has a real prospect of success in relation to supermarket lookalikes. These are obviously just becoming more and more prevalent. We see lookalikes so often in supermarkets nowadays, and this is the latest one in a series. I'm going to hand back over to Julius to quickly chat about how we are looking to move forward in this space.
Rebecca, thank you so much for that. They're both really interesting cases. I actually think the reasoning in that Chanel case is very problematic in relation to similarity of mark. I'd be very disappointed if we'd had that finding on identical goods to where Chanel had a reputation. But the lookalikes decision is a very positive one for us. We've been looking at lookalikes for some time. I won't talk about it in great detail, but I hate lookalikes. I think they're dreadful. I'm a pro-brand person, and I don't like the fact that people are doing exactly what the court there said. They are deliberately designing around to avoid confusion, but in doing that, why are they doing it? They're doing it to take unfair advantage of the reputation of the brand owner. We stand for brand owners. We stand squarely with them. I want to get rid of lookalikes, at least in the UK, and so for us, we want these cases. If any of you have these sorts of issues, we will find some form of creative way to make them move forward. Whether it's a creative fee arrangement, a DBA or a CFA, I would like to get rid of this issue in the UK. So I know that's probably quite a big statement to make, but I don't like them, and I would like to get rid of it. So if any of you are working for brands that have these issues, please come forward. Please come and have a conversation with me. I want to take these cases forward. We need some decisions that go along with this Scottish decision that finds unfair advantage in relation to these issues, so that mainly the supermarkets, not only the supermarkets, but mainly the supermarkets don't do this moving forward. Thank you very much for that, and thank you, Rebecca. I'm going to briefly talk about Brexit. I'm so sorry. You must be unbelievably sick of this, and so I'm just going to talk very briefly about it. As for all of those who are listening in the UK, I'm sure you would confirm to our international brethren that there are no issues at all in the UK at the moment. We don't have any food shortages or petrol issues, and Brexit hasn't impacted on us at all. Fortunately, our government has told us that this short-term pain, at least they acknowledge that there are some short-term issues now, will be beneficial in the long run. We have had an immediate understanding of the impact of Brexit because our hampers could not be delivered to Germany. Hence this slide. So for those of you who are listening in Germany, you had received an alternative, which we had to source locally. So all of this discussion about clotted cream fudge and apple biscuits, you probably thought, what on earth is going on? But we couldn't get our locally produced hamper to be delivered to Germany, I think probably because of Brexit issues. In terms of, we had to put that in. We do have a fruitcake in the hamper, and there is another one there. I won't dwell on the issue. In terms of briefly trademark issues around Brexit, sorry, Francois, I know, terrible beer. A few things just to touch on. The trademark issues were never too significant in relation to Brexit. The EU rights have been cloned. The UK IPO have mainly concluded this. We're trying to get confirmation that all of the rights have been cloned, but certainly all of the ones that we've had any dealings with are all now completed. So that's useful. In terms of issues that were still outstanding, a few things that are quite useful to understand post-Brexit is things like pending cases where the earlier right was a UK right. It was clear in the rules that would mean if an opposition or a cancellation was based on a UK right, it would fall away post-Brexit. That has happened. That issue has been appealed, and the the boards of appeal, OHIM, EU IPO will not look at those decisions if the only earlier rights were UK rights. Quite rightly, as the UK is no longer part of the EU. They won't allow a party to broaden the scope of an opposition or a cancellation action because their only earlier rights were UK rights, which is quite an interesting issue. So if your case was only based on a UK right, but you had other rights, you're not able to expand the scope of that after a Brexit, post-Brexit. You may, of course, be able to take further action once a decision has been issued dismissing your case. One of the things that we're still waiting for determination on is what happens to the equivalent UKs when there has been a decision in relation to the equivalent UK case. The rules say that a UK right, effectively cloned out of an EU right, where there is a pending decision relating to that EU case, should follow the EU case. There are a couple of things to note. It's clear that this needs to be notified to the UK IPO. So if you're the party attacking the EU right, once successful, you need to notify the UK IPO. If you're the party defending that case and you think the decision should go the other way, i.e., yes, there was a decision on the EU right, but the UK decision should be different. For example, it's a use issue and the use would have been sufficient to maintain a national right but not an EU right. Or it was a confusion issue and there wouldn't have been confusion to a UK consumer, even though there was in other bits of the EU. Those sorts of issues, it's on the party in question to notify the UK IPO and deal with those cases. There are no decisions yet in relation to those issues, but they're things that we need to be looking out for as time goes by. Last point, briefly on Brexit exhaustion. You've probably seen a little bit of discussion on that. Exhaustion is now a lopsided issue. In the case, effectively, the UK maintained EU-wide exhaustion position. So products first put on the market in the EU can be brought into the UK and rights are exhausted, but the position is not the same the other way around. UK government are looking at a consultation on this issue, but I have literally no idea on timescales, and there appear to be quite a lot of other issues going on. So I would anticipate that position will remain for at least another year or 18 months pending a consultation. And that was it. That was a very brief couple of comments on Brexit. If anyone has any concerns about any of those issues or other issues relating to Brexit or any of the cases that we've discussed or I mentioned or Rebecca mentioned, or you want more detail about any of them, please do reach out and I'd be delighted to go through it in more detail.